Hello, and welcome to Vercom's Email Threats video series. In this video, we'll be talking about regulatory, legal, and storage hazards, what they are and what risk they pose to your business. Data breaches are now a common sight in today's news reports, with large corporations regularly losing tens of millions of records full of financial transactions, credit card numbers, protected health information, and personal identifiable information. What is often not discussed amid the success of these attacks is what smaller companies can do to prevent data breaches while also managing the regulatory, legal, and physical risks, fines, and challenges that are more easily weathered by larger companies. Smaller companies, particularly those in healthcare or financial services, and subject to regulations like HIPAA and FINRA, need to employ proper data protection, encryption, archiving, and other measures, or they risk being exposed to fines, regulatory censure, and even legal liability that could otherwise crush many smaller companies. First among these are the risks present when transferring sensitive client or patient information by email, which is fast becoming the norm. Organizations must deploy email encryption and data loss prevention technology to ensure that employees can send email through an encrypted platform, stored at state with the highest secrecy and security available, and also stay protected by automated policies that encrypt any email containing certain recognizable, identifiable information, like social security or credit card numbers, and industry terms, like those relating to financial transactions or brokering. Record retention requirements also play a role in regulatory compliance. But beyond industry-specific regulators, effective email records with e-discovery are fast becoming compulsory, as research shows that 55% of businesses will be required to produce email records in court at some point in their lifetime. Furthermore, the risks of natural disaster or network issues make it important that such records are stored in an off-site, secure cloud environment. Beyond the risks posed by regulatory and legal requirements, going without filtering can also seriously enhance the liability businesses face if they fail to protect data. Legal precedent is slowly being established for this, as in the case of one Washington, D.C. area title agency that lost a client over $1 million to a business email compromise attack, but is now being sued for nearly 10 times that amount in damages, both for not deploying email encryption to protect their transaction and not deploying effective email filtering to stop the attack from happening, all while being implicated in RICO Act violations and having to produce a whole trove of documents for their ensuing legal battle. To stave off the myriad of regulatory, legal, and storage hazards businesses face today, Modus Cloud includes email encryption, data loss prevention, and email archiving services that provide your employees secure communications, prevent inadvertent disclosures, and keep your data stored and secure, all along with email filtering and advanced threat protection that our customers have come to know and love. To stop regulatory, legal, and storage hazards from affecting your day-to-day work, contact Vercom to learn more about our Modus Cloud solution.